The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much. On behalf of the panel, good morning to the attorneys who are here. I want to introduce the panel to you. My name is Ariane Buno. I'm joined by Justice William Mead and Justice Maureen Walsh. The case we're going to hear today is Department of Children and Families versus Father and Another, 2022-1214. I remind you, of course, that this case is impounded. And briefly, Attorney Lowe, before you begin your argument, I just want to remind everybody here that we do have a policy regarding motions for remote arguments. And as you now know, it requires that the party requesting remote argument to demonstrate good cause. I know that there was a couple of motions filed in this case, and this one was, the last one was eventually allowed, and that mostly because the first one did not have sufficient information for us to determine whether or not good cause existed. So it's a new policy, I recognize that, but it's on our website and it needs to be filed in order to have these motions allowed or denied expeditiously. So with that said, I'm going to ask Attorney Lowe to begin her argument. Thank you.
Thank you very much, Judge. May it please the court, my name is Lorna Lowe and I represent the father in this case. There's no question that my client has a lengthy criminal record, arrest record, a carry on which the lower court heavily relied to find unfitness. The court's reliance on it, though, was problematic because aside from 2 convictions, which were more than 10 years old at the time of trial, father's carry was made up mostly of charges, 23 on which the court relies to support 25 findings of fact and 12 conclusions of law, demonstrating the central role that these charges were given in the ultimate finding of unfitness. As the SJC held in Care and Protection of Frank, cited in my brief on page 14, the judge can rely on criminal convictions because convictions are probative value and are therefore relevant in a determination of unfitness, but I'm unaware of any case that says the criminal charges are probative of unfitness, I beg your pardon, and thus reliance on them to find unfitness was prejudicial error. I will focus my argument on this issue and time permitting. I'll also address the other 2 areas the court addressed to find unfitness, which were services and bonding. Father had a criminal record when DCF placed his 18-month-old daughter with him on March 1st, 2019. And when the department removed her 15 months later on June 5th, 2020, it was because the department learned that father had been arrested and immediately released 6 weeks prior. The court recites the charges, but doesn't make any specific or detailed findings that these bad acts actually happened, only that the father had been charged. The court goes on to say that these charges are evidence of instability. However, that's a bootstrapping argument that is untenable as it's an end around Frank. DCF argues in its brief on page 39 that if any of these charges actually became convictions, then father would in the future be unavailable to parent. However, that's a misreading of GLC 119, section 24. I'll move on to father's action.
He does have a lengthy criminal record apart from the charges, though, correct?
No, Judge. There were 2 convictions that were on father's carry at the time of trial, and those were 10 years old and 15 years old, respectively.
But the child was present for a criminal behavior in the home, including drug raids and father getting stabbed and shot at the house. Is that correct?
My understanding, Judge, is that I don't have at my fingertips the exact number of times that the child was present. But I do know that when the detective did testify at the trial, I believe that there was one that didn't note that the child was present in her in the police report because she was asleep at the time and said that she wasn't disturbed, that sort of thing. But I don't have at my fingertips the exact number of times.
She was asleep during the drug raids, or when he was stabbed, or when he shot himself?
I don't believe any of those allegations were actually proven, Judge. However, I believe that
that was the understanding of the police, was that he shot himself, right?
I believe that was the understanding. That was a charge. I believe that was not something that was ever resolved.
I'm just
Well-
trying to figure out when was she asleep? During the drug raids or when he
I
was
believe
shot?
it was one time when the apartment was raided. The building was raided twice. He was living in an apartment building. And the first time for the first raid, I believe the raid was in the basement of the building. I believe there's 6 units in this building altogether. So it's not father's house, that type of thing. And so he was never charged. And then there was a second raid that was done on his apartment. I believe she was there for that.
You seem to be concentrating on the judge's emphasis on criminal history, but there was also findings of fact regarding employment and housing stability. And there was a connection, was there not, between father's criminal, I'll call it behavior, because of course not some of the incidents, the gunshot stabbing, the drug raid, etc., did not necessarily result in actual convictions, but that behavior did contribute to instability with respect to housing and employment. Is that fair to say?
I would respectfully disagree, Judge. There was no evidence that came in or that I'm even aware of that any of these incidences led to housing instability. I believe that he had also, in terms of employment, I believe he had also left the previous employment that he had with Atlantic Lighting before any of this actually happened. In terms of the housing, my understanding is that he's still living at the same address that he was when all of this happened. So he had been living there for years before this happened and is continuing to live there. So
Was he paying his own rent at the time?
I beg your pardon. He did have some financial help from his family.
Weren't his siblings paying for his entire rent? He wasn't earning any money at the time, my understanding.
My understanding, Judge, is that he had applied for benefits and that at least one of his siblings was helping him out financially.
Counsel, can I just make sure I understand your argument? You're claiming that the judge erred in considering criminal conduct. Is that true? You're limiting the care and protection of Frank to convictions. And so if a judge were to look at a record and it was a 10-page record, 9 of those pages resulted ultimately in dismissals, but a pattern of behavior of violence or abuse. Your position here before the court is that it would be error for the court to consider that in its calculus.
Actually, no, Judge, I'd respectfully disagree. I believe that the court can consider it. It's just a matter of what the court considers. What I'm arguing here is that the lower court actually conflated convictions with charges. And in Frank very, very specifically delineates the distinction between the two and says that, in general, in its notes that, actually, I'm sorry, not in its notes, but in the body of the decision, says that while some courts that have discussed adoption and custody have held that quote unquote specific acts of misconduct might be able to bear on character, not citing any specific cases, but then immediately in Frank, they cite Commonwealth versus Tobin, which says that evidence of wrongful behavior is inadmissible to prove character or criminal propensity. And in the very next sentence, Frank says definitively that convictions are not dispositive of unfitness, but may properly be weighed in the balance. So I think that Frank says that, yes, a court can certainly consider any evidence that can come in. Certainly, trial counsel filed motions in limine to restrict certain portions of police records, the carry, police reports, that sort of thing. But we're not challenging it as clearly erroneous that the judge looked at it.
So specifically, where did the judge go wrong when considering your client's criminal history?
We're saying that the judge went wrong in considering and heavily weighing these charges. The judge goes on to cite in 25 findings of fact and 12 conclusions of law, and thus making these charges play a very central role in the ultimate finding of unfitness, and that's where we're saying that the judge erred.
Thank you.
Thank you very much, Judge, for your question. If there's no further questions on this issue, I'd be happy to move on.
Please do.
Thank you very much. In terms of father's action plan, regarding the services on his action plan, Adoption of Yale, cited in my brief on page 18, says that services must be tailored to an identified problem. There are 3 different services that the court looks at in its balance of in weighing unfitness, and those are substance abuse, domestic violence, and mental health. In terms of substance abuse and mental health, I'm going to conflate those 2 just because I see I've only got about 6 minutes left. Simply, there's no evidence that came in that said that father had a substance abuse problem or that he had a mental health problem. It was only based on a distribution charge that the DCF deduced that he might be using drugs. There's absolutely no evidence that he came into any of his visits over a year and a half of visiting with his child on a weekly basis. Over the year and a half that she was placed with him, there was no testimony, anything that came in where he was ever under the influence, inappropriate, high, anything like that. And in terms of mental health, he's never had a mental health diagnosis. In terms of domestic violence, there is some evidence that came in that I did not challenge as clearly erroneous. However, the bulk of that history predated DCF placing the child with him. Those were the restraining orders that were mentioned that came into evidence were present when DCF placed the child with him. And the DCF was continuing to ask him to re-engage with a second domestic violence program while the child was placed with him, which he continued to not do. And the fact that the child was continued to be placed with him and the department didn't do anything to sort of threaten to remove her if he didn't do a second program, that sort of thing shows the department's lack of real concern about him re-engaging with domestic violence education.
But wasn't there evidence that there was continued domestic violence in the house?
Well, I'm glad you brought that up, Judge, because while the court does say in its findings that the court finds that some abuse occurred, those were not specific findings about any specific acts that had occurred.
But it was with the partner with whom he was living at the time, who was also aiding in care of the child.
Well, to your point, Judge, that's what's unclear, because the judge does not specifically say this act happened with a specific partner. The court says that it found that some domestic violence, some abuse had happened, but did not find any specific acts. I'm noticing I've got 3.5 minutes left. If I can move on to bonding, but I'm happy to answer any questions if on that issue. Thank you very much. Finally, in terms of bonding, and I'm glad I have the opportunity to get to this point, because where I'm able to finally bring out some of father's good facts, of which there are many. And in terms of bonding, critically, the judge hasn't satisfied the statute on bonding. In conclusion of law 33, the judge does not make the required finding under subfactor 7, which requires a finding that, quote, the parent lacks the capacity to meet the special needs of the child. The lower court makes no specific finding regarding father's capacity to parent this child, and therefore does not satisfy this critical 5th prong. In finding of fact 114, the court does acknowledge that over 1.5 years of weekly supervised visits, and conceding father had missed a handful of those visits, not many, but he was doing so well and they were so positive that the DCF eventually placed they moved to overnight visits, placed this child with him for 15 months, and for 9 months while his daughter was placed with him, he worked cooperatively and successfully twice with a parenting mentor who was in his home, mentoring him one-on-one, observing his hands-on parenting, observing him with his daughter, which was far more practical and useful than the weekly support group of other dads like Nurturing Fathers, for instance, as DCF had recommended. The child was visible in the community. DCF complimented his home as being clean, appropriate, food, toys for the child. She was always presented as clean. There were no 51As filed by the child's pediatrician, eye doctor, the parenting mentor who was observing her at times twice per week. And he was integrating her with her extended family, her sister, cousins, friends, other relatives. He's got a number of siblings who were coming to the home, and he had help, as all parents, especially single parents, need. And that opposing counsel and the court have demerited him for having help from his girlfriend is patently unfair. as it's not a standard that we would put to a two-parent family where caretaking is probably never, ever split down the middle. In closing, had the lower court balanced evidence that was allowable by precedent in the fitness analysis, there would not have been enough to find unfitness, and father's rights wouldn't have been terminated. On that basis, we're asking that this case be remanded. If there's no further questions, I'm happy to rest on my brief and appreciate very much your time.
I'll check with the panel. I don't see any further questions, so I'm going to thank you very much for your argument and
Thank you.
turn now to Attorney Frizzoli.
Thank you. May it please the court, my name is Carol Frizzoli, and I represent the Department of Children and Families. This case demonstrates a father who, despite being given the opportunity to parent his daughter, has continued to engage in behaviors that place his daughter at risk. Father has continued to expose his daughter to the risk of her safety and well-being by continuing to be the subject of drug raids, violence in the home, including being shot and stabbed, and engaging in domestic violence in his relationships. Father has a lengthy criminal history, including a current open drug distribution case that suggests a level of uncertainty and instability on his daughter. During the pendency of this case, Father was shot himself while standing on his porch. He was then stabbed at his residence where he was residing with his daughter. She was present during that incident. Father's home has been raided by narcotics detectives on at least 2 occasions, once while he had placement of his daughter. While his daughter was living with him, Father engaged in a confrontation with a neighbor where he punched a window out of anger. Father's criminal record reveals 23 entries of assault on a person, as well as robbery and drug distribution charges. Father has failed to acknowledge any responsibility for his criminal behavior, most notably blaming the police for the drug raid on his apartment, which resulted in his daughter's second removal from a parent's care. Father's criminal record indicates 34 charges, including but not limited to charging with assault and battery with a dangerous weapon, threaten to commit murder, strangulation, or suffocation on a pregnant woman, which would be the mother in this case, assault and battery on a household member. Father was the defendant in 2 209A orders, one obtained by his former girlfriend and mother of his other daughter in 2015, and the other.
I may interrupt you for a moment because we're familiar with Father's record, but one of the questions that's been raised here is whether or not how much weight should be given to that record in particular, because many of the things you've just mentioned, right, just recently, DCF was well aware of those occurrences before placing the child with him. So there was an evaluation at that point in any event that was
again, DCF placed the child, and DCF wasn't aware yes, DCF was aware of the criminal record. They were not aware of the drug raid that had happened 2 weeks prior to them placing the child. They placed the child on March 1st. 2 weeks prior, there was a drug raid on the apartment, which Father did not disclose to the department, and the department was not aware of it because at that point they weren't getting criminal records. The department found out about that drug raid 2 weeks prior to the placement when Father's partner at the time called the department to say Father had been stabbed in the apartment while the child was living there. She'd only been there for about 2 weeks, and that, he had hospitalization and was in the hospital. She called. That's when DCF ran the father's record and found out about the drug raids, or the drug raid 2 weeks prior to placing. Again, and then the subsequent drug raid, which happened, that resulted in her removal. Again, the police did not file a 51A. It's actually noted in the findings that the department was having problems because the Fall River police at the time was not filing 51As, even though the child was present in the apartment at these times of the drug raids. So the department was only learning about this fact after the fact, during home visits or what have you. So again, that's when, so DCF was a bit behind knowing all this, but that final drug raid was the final straw where the department, and that during that investigation, the department learned that father's partner had moved out of the home in that prior February. There was allegations when they spoke to the child of that partner that there was domestic abuse in the house, that she had left. This continuing pattern of domestic abuse with these, between father and his partners at the time. So again, this is not just, and all of these findings are not challenged. So it wasn't just that the trial court emphasized, the criminal record. It was the criminal behavior compiled in addition to the domestic violence, in addition to not providing a safe and stable environment for this young child. And to go further on that, the conduct of the father continued even after the removal of his daughter. In addition to him not doing any services to address some of these parental deficiencies, refusing to do those services, his criminal behavior continued. There was a incident where he was a witness in a harassment complaint at a house. There was a second incident where he was a suspect in a stabbing outside of a convenience store. All of this was testified to by the detectives at trial. And the third there was a third drug raid on his home after the child had been removed. So this continuing criminal behavior continued, which would place this child at risk if she was returned to father. And that's what the trial court relied on. So again, besides his criminal record, the father refused to either address any of these shortcomings, what resulted in the second removal of his daughter through services. He had said, I would only do services if ordered by the court. And although the trial court acknowledged that father's visitation was very beneficial in this case, but the visitation in a supervised setting didn't outweigh all the parent deficiencies in this case, namely not providing his daughter with a safe and stable environment and continuing this criminal behavior. And again, the domestic violence with all of his partners, and while his daughter was present and living in his home. So again, the trial court properly determined that father's continuing to engage in both his criminal activity and his abusive behavior. Father has never made parenting his daughter a priority in his life, and its history of placing his own needs before hers and a long-term failure to participate in service is indicative of future unfitness and not merely temporary. With this in mind, the trial court found the father was presently unfit and terminated his parental rights. So without that, I rest on my brief, unless there's any other questions.
Seeing none, no, thank you for your argument. Attorney Shokier.
Good morning, Your Honors. Richard Shokier for the child. May it please the court. The child's asking this court to affirm the lower court's orders and decrees freeing her for adoption. Father's life is one of chaos and violence. There's great risk of harm to this child should she be returned to his care. And the court took preventative measures to ensure that she would not be returned to such a chaotic violent environment. Father's criminal history, though the court did rely on it heavily, just the sheer weight of the criminality demanded the court's scrutiny. He has numerous charges, convictions for crimes against the person, weapons charges, drug dealing. The drug raid that resulted in the child's removal was open at the time of trial. And there was also interrelated criminality with the relationships that he had with mother and the mother of his older child. He strangled mother to the point of her unconsciousness while she was 5 months pregnant. After that, after the child's removal, he battered his girlfriend to the point of where she left the state. And she was actually functioning as a primary caretaker for the child. The child had special needs involving early intervention services and ocular problems for which she needed routine checkups. At trial, father had no idea what anyone was talking about. It was actually the girlfriend that testified that she was taking the child to all the appointments. He couldn't even remember what she was diagnosed with. But this is all just one issue in a constellation of parental shortcomings that were available before the court. His criminality, his domestic violence with mother, his past, the other mother, and his current girlfriend, the chaos of the stabbing and the shooting, that even though there wasn't a 51A file, the child was in the house. If I can address the issue more clearly, I believe that the stabbing took place at 2 o'clock in the morning. And since father was outside of the house and the child was sleeping, it didn't warrant a 51A. However, he continued a chaotic and violent lifestyle. After the removal, as Attorney Fazoli spoke to, there were 3 incidences, one of them where he was a suspect in stabbing. It was only not pursued because the victim refused to go forward with anything. It doesn't alleviate the fact that this happened, and these things are clearly documented in the record, and the judge was well within her discretion to rely on it. Beyond that, there was absolutely no cooperation with services, which the court made concluded that father accepted no ownership, no responsibility for any of these matters. He wouldn't even speak to the issue of him choking mother to the point of her unconsciousness. Instead, he simply just admitted that he was charged with strangulation at some point. Father cannot then use this lack of accountability and lack of failure to engage in services to throw up his hands at trial and say, there's no evidence here. He can't use his failure to engage in services as a sword and a shield at trial. More to the point, the child was present during the drug raid. And if I can clarify that issue, the drug raid took place at the early part of the morning. So everyone was sleeping when the police showed up, where they discovered cocaine on father and very large amounts of cash along with drug paraphernalia. The circumstances demanded the court's scrutiny. There is the fact that he simply refused to participate in services is also probative, as well as his criminal history, as well as his criminality currently, as well as his domestic violence and his propensity towards violence, which if I can speak to this as well, in care and protection cases, this court is well aware that the same type of propensity evidence and constitutional protections allowed for criminal clients are not recognized for care and protection parents. With this said, the child has been in her pre-adoptive home for now 3 years, and the court's order of father's post-termination and post-adoption contact satisfies her transition into her pre-adoptive home. The test of the child's best interest is both parental fitness and her best interest. They're essentially 2 sides of the same coin. So the judge was well within her discretion to order post-termination and post-adoption visits. They are not for father's benefit, but for the child's benefit as she transitions into her new home. With this said, I invite any questions, but other than that, I would rest on my brief.
I don't see any questions from the panel. So you can rest on your brief. I want to thank all three of you for your arguments today. These cases are always very difficult. We know that, and we will give every part of the record our utmost attention, as well as to your arguments. So thank you very much.
Thank you.